This is the Engineer Committee meeting of the Board of Architectural and Engineering Examiners. Notice of the February 14th and 15th, 2018 meeting of the Board of Architectural and Engineering Examiners was posted to the Board of Architectural and Engineering Examiners website on February the 7th. Okay, we'll call to order. We need to take a roll call.
Grateful to be here.
Here.
Robert Campbell.
Present.
Here.
Here.
All right, first thing on the agenda is application review. Wanda, you want to lead us through this?
Well, I sent out the agenda for the application.
Okay.
So normally the
Yep.
chair assigns them to different members.
Okay. Let's see. Everybody's got their list in front of them, I guess, or it's probably on the iPad, very first sheet there. Robert, you want to take Chestine and Godfrey? Those first two. Kathy, you want to take Hilton and John? Ash and Taraski.
I could interrupt for just a second. I just wanted to, before you get into the review of the applications real quick, introduce the director with our centralized programs. Glenn Kupchak is here. He is going to complete the meeting. Unfortunately, I've got a bill at the legislative session that's requiring me to be there, so I'm going to be leaving. I think you're in great hands. Liz will answer any questions, and then tomorrow will be the full meeting. So Glenn has been wonderful putting things together as well, working with the staff and transitioning all these changes, so I want to make sure that you all had a chance to meet him.
The Robbins, the audit.
On the iPads, the
I
updated.
can take Stanford.
Yeah. And I have to, yeah. She said she's kind of put them on there. She didn't have time to do that today. alphabetical order. That's what I'm thinking. We'll get the paper copy.
While we're finishing up, looking at those, we've got a visitor. Maybe we should have the visitor introduce.
That's red when you come in. And
Okay.
state your name.
All right. My name is Najma Jami, and I'm a civil engineer, traffic engineer, but unfortunately not in Tennessee yet. I've been working for 5 years now after graduation, and I took my PE in Virginia and got my license from there. And the reason was because when I applied, I got my bachelor's from Iran in civil engineering and my master's here from University of Memphis in civil engineering again. But they told me one of the requirements was that to get my bachelor's degree evaluated by NCES. And so it was a special case because when I went to my college, I got my bachelor's in civil and surveying engineering, and it was part of off-campus from the main university. So main university only had civil engineering, not surveying engineering. The off-campus now is independent, and it's not part of the main campus. I was able to get my official transcript and degree and send them all to the Tennessee Board and NCES for evaluation, but they needed my course-by-course syllabus to get that evaluation finished, and I wasn't able to get that because main university didn't have that department, and the off-campus wasn't responsive to me because I wasn't technically their student anymore. So I got all those, but I know that I talked to you, and there's a waiver for official transcript if the school is destroyed or something like that, but I don't know if this case could be considered separately because I'm really willing to continue working here, but I know that if I can't get my license, if I can't get those evaluation, I can't get my Tennessee license after 10 years, and that's a long time. So I was wondering if this could be also applied to my case, that it's not exactly the same, but because I can't get my course-by-course syllabus, but I have my official transcript and my degree and my master's from here. And I also, when I applied for University of Memphis, they also wanted some evaluation for my degree, and I got it from WES, World Education System, and I told the board that I can request that evaluation again because at that time the school was still part of the main university. So I just came here to talk to you all to see if there is any potential solution for my case considered. I really appreciate it because I'm really enjoying my work, and I love the engineers here in Tennessee, and I like to stay here if I can also improve my career.
Well, thank you for being here and coming here, and that's a good question. Anybody got any comments?
I think to try to get us to tell you something now might be a little quick, but have you sent an application in or anything for us to look at, number one? Number two, I don't know that what we've got in the statute, and I'm kind of looking at one because I'm trying to do this from memory. I don't think it specifically would apply in your circumstance because I do believe it said that it had to be destroyed, something. But anyway, I think we've got some flexibility, but we would need to see the whole application and and not just say, oh, here's what we're going to be able to do. I think we would need to look at it and evaluate it to make sure we're consistent and that make sure that we do have the flexibility to do that. And our goal is to try to do anything possible to keep you, down that path, towards licensure. But without the whole record, I'm not sure we can do a whole
Yeah,
lot.
definitely. I mean, I applied and I talked to the person when I wanted to apply. She said that I need that. And even after I got my Virginia license, I wanted to apply for the transfer to get the license for here too. And she told me that I need to still get my evaluation. So, but you're saying I
think
just go
let's-
ahead and apply.
Yeah, and then just, if we can, just footnote that and say, let us look at it or something, absent of that accredited or curricula.
And if you could put that with your application, that would be helpful too.
Thank you so much. Really
you very
appreciate
much.
it.
Yeah.
Thank you.
And just want to tell you that we do appreciate you bringing it to our attention so that we can try to take action on it. And like Robert said, we want to get you to yes on this. So just send in the whole package, which is much information as you possibly can, and I think we'll go from there.
Okay, the applications, why don't we start through with Robert? And I'll say, too, I apologize. It was probably my duty to make assignments of these when we received this list of names. So, sorry for the
Shortcomings so noted.
for the siesta that we had to take there.
It wouldn't have helped me because I couldn't get the file open.
Okay, all right, so we'd had to wait anyway. Okay. All right, Robert, you want to take us through
Yeah,
Chastain?
so my first one here is Richard Chastain. He's a reapplication. He self-reported that he'd been practicing on an expired license, and I believe it was for a decent amount of time. Kind of blamed it on moving offices and some records not being transferred through there. We have a complaint has been opened against him. His experience, everything is fine. Okay, it's not like he's. But the question I have is should we give somebody a license that has an active complaint without that complaint being acted upon? Because we may give him a license and then turn around and revoke that license during the very next meeting. And I just don't know that that's real helpful until that has been. And maybe we've done that before. I don't know, but it just seems to me that's my thought on it.
Tony can correct me if I'm wrong, but I don't believe we usually deny licenses for a pending. Especially if the claims in the complaint aren't with merit and the potential licensee doesn't have a discipline, but I also don't have the specifics of the complaint you're referring to in front of me.
It says that complaint's been opened, and I would assume that's been from practicing on an expired license. And I don't have the complaint with me either. I just didn't know if we were going down one thing without adjudicating it first, or if we just need to go ahead and then adjudicate it later.
It's a difficult question. I don't have the statute in front of me.
I'm not.
Because out in front of me, normally the boards have the discretion to deny a license if they have a finding that there's certain actions happened by the applicant. So if you have a complaint open, it would have to be based off of just looking at the complaint and saying, well, we choose to believe the person who submitted the complaint, period, and then there's usually a denial on that. For most of my programs, if the complaint isn't something of like a substantial consumer issue or fraud or deceit or something like that, I usually say if they meet the qualifications of application, I would usually recommend to approve an applicant, and then we can deal with the complaint that has been submitted, but it just depends on those allegations, because there are other programs other than yours that when they have complaints that are open, that they if it's been presented to the board for a determination from legal, and we say you can have the ability to deny based. I'm throwing out general ideas right there at that time, because like I said, I would be interested in seeing what the allegations are, and I don't have that in front of me.
Again, I think it was that they performed under an expired license, and I
Okay.
think they did self-report on that.
Okay.
That's what the
when they
complaint
updated it.
is.
Yeah.
I opened an administrative complaint
Right.
because he practiced on
Right.
an expired license. That's what the complaint is.
Okay. As long as we've got some flexibility, that I'm okay in recommending him licensure, waiting, pending, give him licensure, and then depending on what we do, because like you said, it's not something like he went out and designed a
I
building that's
understand.
going to fall down or something.
It's a common occurrence that happens with many of our programs, is that somebody has a complaint for unlicensed activity or an expired license, and then so their next step is usually to reapply, try to come in conformance because we told them. And so usually the best course is to get them in an application. Then on that complaint, usually when we give it back, we can look at the circumstances and we can make a recommendation throughout, whether there should be discipline or what that should be, whether civil penalty and whatnot. So yeah, for an expiration or of a license or failure to apply, that's a normal course. Yeah. Mm-hmm.
I'm okay with recommending that we approve him, and then the complaint will proceed however the complaint proceeds, right? That's the thing.
Okay, all right. So we have a recommendation. You want to make that a motion?
I'll make a motion that we approve him, approve his reapplication for licensure.
Second. All right, any discussion? All right, all in favor, say aye.
Aye.
Opposed? Okay. Okay, Godfrey?
Yeah, Godfrey is an interesting case. It's a applicant's got a Bachelor of Science in Architectural Studies and a graduate degree in both architectural and civil engineering. It says he's only 8 years of experience after his graduate engineering degree. He's licensed in Illinois, I believe, if I remember right. And so NCAAS came back and said his degree was equivalent, met the education standard. They combined all of his education criteria together and came up with it. Dr. Smith, however, came back and said that he was 21 hours deficient total. And so we're kind of caught between two people, one person that says the NCAAS standard that it's okay, and our own evaluator that says that it is not.
Did you say what the deficiencies?
They're in all it graded does not have basic engineering such as statics, dynamics, fluids, electrical engineering, etc. So again, I don't know why the master's program would let you get in without some of those basics, but that evidently that happened. I would think they would make you go back and take a statics or dynamics class, but that seems kind of bizarre to me on the surface, but that's what Dr. Smith notes. And they're basically saying, well, he got a little bit of statics and a little bit of dynamics when he was doing, which is true. When you're doing structural engineering design, you're going to get statics and dynamics in that classwork. I don't know how much double E you're going to get, but I don't have a great recommendation on this one because, Dr. Smith's evaluation, we've used it many, many, many times, but we've used NCAAS's many, many, many times as well. So the fact that they're in conflict with each other, and his experience looks good. His project level is pretty outstanding. It's not a flimsy experience level that he's got.
He's actually demonstrated his ability to practice.
Yeah, and that's the thing that's kind of
no complaints against him, historically.
So, that's the thing that kind of gets me leaning towards that. But then, again, how do we go back and look from a precedent standpoint of, well, Dr. Smith, we've kind of, backed up to that in a lot of cases. So that may weaken.
If we were in humanitarian components, it'd be easier. But it's not, apparently. It's in technical components, correct?
Yes, sir.
Well, and it makes it difficult that, in our state, in our laws, we require the bachelor's of science, and not every state requires that. In some states, it's okay to not have that. Kind of landed right where Robert is on that, just right in the middle of really not knowing what to do. I hate to go against Dr. Smith's recommendations, Does have a good track record and excellent referrals.
Looking, Robert, one thing I noticed, his architectural degree, his bachelor's, his focus was structures. So you wonder, how do you do anything with structures if you don't know anything about statics?
That's
So, and in the NCWS review notes that he's passed the 16-hour vertical structures exam and the 16-hour lateral exam. So that sort of doesn't make sense. That it sounds to me like that he just maybe didn't have the freshman statics course that most of us took. That somehow he got it somewhere along the way, but. I'd hate to beat him up for statics with.
Yeah.
well, no, I mean that's
what he's
my.
got.
I think
There's 21 hours, though, correct?
well, but it includes statics, dynamics, fluids, electrical engineering, and etc. So there may have been a few others, but you're
I
exactly
can see
right.
fluid, and yeah, he probably didn't have electrical or fluid
Right.
mechanics.
But I again with his experience in others, statics and dynamics would be to me easy to say, okay, that's good. You know, he's gotten enough exposure to that. But
I don't think the lack of having those classes has impeded him from being obviously proficient in his profession.
From his track record, I don't think this would be putting public health, safety, and welfare at risk at all. I mean, the only problem I have is just trying to be consistent with our laws and rules. The public health, safety, welfare, I'm not worried about as far as this applicant.
Well, that's exactly what I was going to say, is that with regard to our charge and our responsibility to protect the public, if he's already passed all the structural, he's passed the vertical, the horizontal, he's been practicing for 30 years, he's worked at everywhere from Sargent & Lundy to Thornton Tomasetti, which is a very well-renowned structural engineering firm. I mean, it's hard for me to believe that we have a basis to deny his registration. That's where I come down.
I agree. Are we ready for a motion?
Yes.
I'd like to make the motion that we approve this applicant.
Second?
second.
All right, any more discussion? Okay, all in favor?
Aye.
Aye. Opposed? Okay, approved. Okay, Kathy, Hilton.
All righty. William Walter Hilton has made application for the exam, and the discrepancy is that he says that some of the references that he received when he applied in Georgia are difficult to come by, and he wants us to accept his Georgia application as opposed to making application on the Tennessee forms. And with regard to the references, he wants us to sign off on the references. And I think 3 of us have already looked at this, right? And my position is he needs to apply like everybody else does. And even if his references are hard to come by, we have plenty of leeway to accept different references or explanations of references that he can't get or what have you. But to simply say to a candidate that, oh yeah, we're just going to waive all the rules, I'm not in favor of that. I think we need to suggest to him that he needs to make application like everybody else.
Is there some compelling reason why it was difficult? I mean,
I went back and looked at them. Most of them are dated 2016. It's not like they're from 2004 or something. I mean, they're not that old. I really don't understand why he, except for the fact that it seems like he just doesn't want to go to the trouble. Did you?
I feel like that the reference forms were so similar to ours, and we also have to look at those NCEES reference forms, which are different than Tennessee's. So I think it's the same basic situation. That maybe the problem I had was that we're required to have 3 PE references, and one of his PE references made no marks on the sheet. There was nothing was checked. So
It wasn't a PE. I think that I looked at that one, and that guy was. It almost appeared like he was a family friend or something.
it was a PE.
He was
because-
a PE?
Yeah, he was a PE.
But he
because
didn't
I
fill
was
anything
looking
out.
for 3,
Right.
and there was no approve, disapprove, yes, no. Nothing was checked. It was
That's
just
right.
signed at the bottom.
Signature. Yeah.
And so it seems like he needs to go back anyway and get another PE reference. But I'm okay. I'm okay using those Georgia forms. They're similar enough. But if we want to, as a group, if we want to say he needs to redo them on Tennessee forms, I'm fine with that.
Are more than 2 years old. I think that was the comment that
I didn't see
Robert
any
made.
that were more than 2 years old.
I thought they were.
I think they were all 2016.
I thought they were all older than that. How did
Oh, it's
come up-
2016.
July 2016. I mean, I looked and I did not see any over 2 years. Yeah.
I looked at the thing where he said he had started his application, and I assumed
Yeah.
that may be what it did. Okay. So that's it. But does that raises a question? And I'm not disagreeing anything with what you said, Kathy, about it. You got to do it, but we do accept NCAAS evaluation form. Is that?
Yeah, but do we want to start accepting everybody,
Well, that's true.
every state of the union?
That's
I mean,
true,
every time
because-
somebody wants to apply and they
That's
go,
true.
hey, I'm from New Hampshire and I'm from California and I'm from Kentucky. I just, if for no other reason than the people who are helping us try to review these things.
I'd like to make the motion that we require him to resubmit on the Tennessee State form.
Okay. Do we have a second?
that. Second that.
All right. Any other discussion? Okay. All in favor, say aye. Aye. Opposed? Okay.
Okay, so the next one I had was Charlie Justin Johnson, and he starts on page 185 if you want to look at it. I think the issue was that he had a single negative reference, and it was pretty negative. I mean, the guy basically said, no, I wouldn't recommend him, no, I don't think he's any good, et cetera, et cetera. Robert, you approved it, and I think Ricky and I were like, hey, let's talk about this. I would lean toward approving it, and I'll tell you that it's because the guy is his first employer, I believe it was, and it's about at the edge of the 4 years. Everybody else after that gave him strong positive recommendations, and a lot of the people that made references, I don't know the guy that gave him the negative. I don't know why he would say that, but maybe he left on bad terms and he's just trying to. But he had 5 positives as opposed to 1 negative. And one of my questions was, do we have the leeway to just throw out one of the? He's got 5 positive, and that's the rule. So
I think that is the rule that you can, I think it actually states if you have a negative reference, you can substitute one in there.
substitute a new one. So he's got the 5 positive. I would suggest we move on. Approve him.
Second.
Okay. Any discussion? All right. All in favor, say aye. Aye. Opposed? Okay. Approved. Okay. Let's move to Steve.
First of all, I should disclose that I know this gentleman, so I guess you can tell me not to. I don't know. He's not a friend. He was on a team that did some work in Knoxville.
Yes, can you review it impartially?
Well, I have an opinion. And he's also, evidently, somebody turned him in for what I probably should have turned him in for in Tennessee and Alabama.
Is that already noted in the,
It's a part of the record.
okay. Do we have enough numbers here to vote if he?
Or 6.
At a quorum.
Yeah, so, okay.
So you want me to discuss it or not?
I think you can share your, but I think you might want to refrain from voting, but I think you're welcome to share your,
And just for the thing too, just because we know somebody and had experience
Yeah.
with them is not necessarily a recusal. I mean, we're going to know a lot of people.
Yeah.
You know, and that's nature of the beast.
Elizabeth, just for clarification, can he can introduce information based on his opinion of the information delivered in the application, but what about his personal experience? Can he also introduce that?
I'm not seeing anything in the statute that says he can't, from.
If he can, I'd be interested in hearing Steve's opinion, personal opinion.
Maybe we can start by going over what's in the iPad. He's a well-experienced individual with appropriate education, but he got in trouble in the state of Alabama because he wasn't licensed and he proclaimed to be a professional engineer. So there was an agreed order. Also, in Tennessee, a similar thing happened, and I was really surprised. I didn't remember this. There was a consent decree in 2014, but the complaint was opened in 2010, so I wasn't on the board, I don't think, in 2010, so that's why I didn't remember it. But it was a similar thing, but this happened not in Knoxville, in Memphis, where he claimed to be a professional engineer. And I guess what's happening now, he's applying in Tennessee. So I guess he's doing what consent decrees in 2 different states told him that he needed to do.
And here's a question that if I can kind of jump in with what's in the record or what the application that we were sent. There's this NCES page with a list of questions, and
What page is that, Ricky?
it is.
Or are you on the iPad?
Know what page this starts?
I think it was 205.
Okay, this is page 221. Says, have you ever been reprimanded by a jurisdiction? If yes, identify jurisdiction and explain, and the answer is no. And I don't understand that. I would think a complaint is a reprimand. I know the other question, I've always wondered why we don't ask, have you had any complaints against you? Because a lot of times that's material maybe to the application. We just say on our Tennessee form, has your license ever been revoked or suspended?
How do we know when he filled that out?
This I think I saw a date.
There's a date at the bottom of the page, but is that the date that he would have completed that form? 10/3/2017.
Yeah, it looked to me like this was filled out in 2017. That's what I thought. And these 2 occurrences were, like you said, 2010 and 2014 or something like that. That didn't give me a good feeling. No answer there. I mean, I would consider a complaint a reprimand, but maybe that legally is not.
But in the Tennessee one, it shows that he had to pay a $500 penalty.
And that's why I don't understand why the form was answered with a no.
No kidding, yeah.
Yes, if they signed it, they agreed to discipline, and usually what they've agreed to is in the line. The consent orders that we write, yes, it is discipline. It'll be listed specifically that they violated in the order. Mm-hmm.
I had a question about that.
That's pretty much the gist of it, but just for your information, the Alabama order was signed October the 6th of 17. July the 14th, 2014.
I've got the attestation at the very last thing on the application says, I hereby attest that the above information and documentation provided is accurate and true to the best of my ability. I further understand that providing false information may result in the denial, suspension, or revocation of any license, certificate, or permit issued.
Alton, that's the Tennessee form, correct? See, in that one, the wording is a little different. It doesn't, it just says, have you ever been denied registration or had your professional license suspended, revoked, or voluntarily surrendered as a result of disciplinary proceedings? So on that one, he answered no, and that's correct.
If the board would like, I can read the denial, suspension, or revocation section of the statute just as a reminder of the factors. A1, the board may refuse to issue or renew and revoke or suspend the certificate of registration of any architect, engineer, landscape architect, or registered interior designer registered hereunder who is found guilty, A, of any fraud or deceit in obtaining a certificate of registration, B, of gross negligence, incompetency, or misconduct in the practice of architecture, engineering, landscape architecture, or in the use of the title registered interior designer, C, of failure to obtain, keep, and utilize the registrant seal as provided in this chapter, D, by a court of competent jurisdiction of breach of contract for professional services, E, of any violation of the rules adopted by the board, F, of having the person's right to practice architecture, engineering, landscape architecture, or use the title registered interior designer suspended or revoked by another state or national registration board, or G, by a court of competent jurisdiction of any felony. 2, any person may prefer charges in writing to the board against any architect, engineer, landscape architect, or registered interior designer registered under this chapter on any of the grounds listed in subdivision A1. 3, the affirmative vote of 5 or more members of the board shall be necessary in order to revoke or suspend the certificate of registration of any architect, engineer, landscape architect, or registered interior designer registered under this chapter. The rest talks about reissuances.
Can I go back to my original question? Can Steve enter a personal opinion?
Yes, he can.
Okay.
Just make sure you're voting for approval or denial based on the factors I just read.
And I'll just add to that, is that my understanding is that what you're going to talk about has to do with what was in the application, sir. So it was what surrounded with the application.
That's not what Alton's asking me to
No,
do.
it's not.
I mean, if you have general specific like knowledge of someone personally that you had dealings with in the past, and it's not part of the application, and what you're talking about is not relevant to a denial, meaning there's no statutory authority, then it would not be proper to talk about. Is the only guidance that I would give, because I have no idea what you're about. So I would just say that. But if it has to do with some circumstances surrounding what happened,
What
I
about
believe
if
in
it's
Alabama,
about a project he lists in his experience?
Oh, okay. And that was what the project was. That issue was in the application. Yeah.
The project's in his experience where he worked in Knoxville, and that's my knowledge.
Okay. Yeah.
Okay. for
No,
him.
I'm okay with that.
Okay.
Yeah. I'm sorry. This
Because
kinda
it
took a
seems
while.
like from what you've read, he violated 2 of the subsections, the rules of the board, and there was one other one.
Other states' jurisdiction.
So he violated.
I think he violated, I think it mentions in the Tennessee order 101, that's the Title Act, isn't it? Where he claimed to be a PE, but he wasn't. And that was the same thing in Alabama. But the 2 projects that I'm familiar with that he worked on in Knoxville was the South Knoxville Waterfront Master Plan. And portrayed itself to be, I mean, there wasn't a set of drawings produced, but certainly in public meetings, the public would have walked away thinking he's a professional engineer, because he talked about traffic issues, particularly issues where the trend now is to do road diets and narrow lanes, and the public would perceive that he was speaking as a professional engineer. The other project was Cumberland Avenue project. He was on the master plan team for Cumberland Avenue, not the, there was a different consultant that was hired to do the detailed design, but Walter Kulosh was on the master plan team. And in my opinion, he should have been turned in at that time. That's not really, we're discouraged from that in Knoxville.
Was he speaking to the public
Yes.
on
Yes.
behalf of the design team?
Master plan team, yes.
Okay.
About traffic issues. And I don't know what I'm saying is arguing to give him a license or not give him a license, because, you know, he's certainly one that needs to be under the umbrella of a regulatory board to give him a little guidance along the way. But also you've got this situation where he answered the question in 2017 that he hadn't had any disciplinary action. So I'm sort of at a loss. I was disappointed to find out that he wasn't licensed, because I looked it up. This was done. You'll remember this was in the Haslam mayoral administration, and several firms were hired because of a particular employee that didn't make sure consultants had the proper license when they were hired. And I was able to change that down the road when I was promoted to a different position, but this was one of the first contracts.
You have I'm sorry, go ahead, Ricky.
I was just going to say you guys know this. I didn't know him at all, but he's got glowing reviews in terms of people calling him a national expert and that sort of thing. And
He's a national expert with transportation planners. Most civil engineers and traffic engineers won't have such a glowing recommendation. So that's what you see. You know, and we're in a different world than when we started out, Robert, in civil engineering with roadway stuff. You know, it's more about, you want to create congestion now to slow traffic down. You know, years ago we wanted people to be able to get to work. It's just different now. So I don't know whether I'm arguing to approve him or disprove him, but that's my impression.
You have a recommendation?
Well, I don't know what to do about the fact that he lied, but I guess we need some guidance from legal on that. That could be significant.
That can
Well,
be considered a violation of the board's rules.
Well,
I'll go back.
before we make a recommendation, can I ask a question of legal? So, just like we were just now talking about the person before, is it proper to authorize him to receive a license and simultaneously open a complaint against him for submitting false information in his application? It seems like the whole issue is that maybe he should be licensed, but he's done some bad things.
So I think you have grounds to deny the license for the false answer on his application. That could fall under violation of the board's rules. You could approve the license and also file a complaint, and if he's found guilty of that complaint, you can assess discipline. But under the statute, it says that the applicant has to be found guilty of one of these violations for you to deny it. So I don't think you can create like a pending approval based on now.
But it sounds like if we just turn down his application, there's no penalty.
Well, he won't have a
Other
license.
than the fact that he
I
won't
mean,
have a license.
That is a penalty.
that is the penalty. Yeah.
Under-
Of not getting the
Yes.
license.
Yeah, he could reapply,
Yeah.
but he
Under
wouldn't
the-
be granted a
Yeah,
license.
under the statutory scheme, not granting a license or taking a license or suspending a license is the top tier of disciplinary action. Civil penalties were always put in schemes as general deterrent, specific deterrent of bad actors out there, and they can be added with it. In some instances, we've had instances where boards want to, we will grant a license if they will sign a consent order admitting to their whatever activity and paying a civil penalty of $1,000, and that's it. Like they're do that they say we'll grant a license so long as you admit to these violations because it's right here glaring in front of us. And we have done that before with some other boards. I don't know if we've done that with this board before because I'm not sure if it comes up
Well, the reason
as often.
And I totally agree that if this were a young engineer with 10 years experience who wanted to come to Tennessee and practice and make a living, then not granting the license is obviously the highest penalty available. But this guy has 42 years experience. He's at the end of his career, and he hasn't previously seen that he needed to be licensed in the state of Tennessee. And if we say, no, you can't have one, he's probably going to say, oh, okay. And
I didn't need one anyhow.
I didn't need one anyway. I've been doing what I've been doing, and if you don't want me in your little club, then I don't care. I mean, that's part of my concern is that he's then going to say, publicly or otherwise, well, I tried to get my license. They wouldn't give it to me. And so I'm just trying to see if is there a way that we can, quote unquote, grant his license application and discipline him in such a manner that is constructive, as opposed to just pushing him away. Because I look at his application and I think there's no penalty for us telling him no. I mean, if we don't grant him a license, he's probably not going to fail to make a living. He's already self-employed part-time.
Well, I think that the answer is what Liz said, approve his application and then open a complaint. It seems to be the avenue if we're going to do that.
What would we open the complaint based on?
Falsely
False
filling out
information.
But
But like Ricky said, how it reads in the Tennessee application.
This on the NCAA,
This is on the
NCAA
form.
application.
Oh, okay.
That's the one that I.
Good. I didn't see
You
that.
could also file a complaint for, you said he was using the title without being registered.
Yeah, but I think that's something that I think that ship's probably sailed a little bit because it sounds like that was pretty good time in the past.
Yeah, I mean, for what your suggestion was, is that, I mean, the short answer is we can. Legal could help like that, where you all could say, we recognize that we could, based on this right here, deny your application. We have that authority. You have no right to appeal, nothing whatsoever. It is not a property right. That's fine. However, if you would like a license, we will approve it if you agree to pay a civil penalty for these violations that we noted in your application. Legal usually would help with that. I just brought up, I don't think we've done it with this board before because we've done it with other boards, smaller boards and programs. It's not something that happens a lot. It's usually an application issue. I think our contractors board probably sees it more often than not with unlicensed activity or whatever, or some issues with that. So we could, if that's something that you all want to discuss to do, we could do it that way on the front end. We could absolutely do it the way you just discussed with Liz. Grant the license, open complaint, legal will process it like everything else. So there's some options out there for you all.
And I think that's the way I'd go ahead and make a motion to do that. I think we'll go ahead and approve and then open a complaint on approval. And then I'm going to add just a caveat to that. I mean, it seems like to me that we potentially have an issue with honesty. I mean, portraying themselves as something, and they're in that world where it's a lot about crayons and boards and stuff, right? Planners can never be wrong because the plan can always be changed, and they don't actually have to put something on the ground that is constructed, and that's been my whole heartache with that whole industry. But I think my motion would be that, is there any way as part of that complaint process to, how do we get it? Is this just an oversight, or is this a pattern of being a little liberal with the truth?
Isn't that part of the investigation, though?
Well, the complaint may not. It may just, because it may be an agreed order that says, hey, by the way, you filled this out wrong. We're going to recommend $500 penalty, and, all you have to do is sign on. And the board obviously have to approve that, but.
I think either route that we take, it would show a history of complaint on this applicant's licensing file. So if he did make a subsequent violation, that information would be brought to the board in your consideration of discipline down the road.
Yeah, I kind of like that, Robert, because I feel like if it is a trend or a problem with him, and he goes, say he goes to a City of Memphis meeting and does kind of the same thing, and we become aware of it, then that is obviously repeat offender. That's pretty egregious, and multiple pieces of paper that back us up on that. I mean, if we weren't talking about the fact that it looks like there's a discrepancy of his self-report, he's not acknowledging that he's been that he's entered into an agreement, we'd approve him because of his application. On the merits of his application, we'd approve him. I just want there to be something in the history books that shows that he did it wrong.
Here, I'll reset the motion. I make a motion that we approve Mr. Kulash's application for licensure, and that we instruct staff to open up a complaint based on the answer that he gave about no reprimand in other jurisdictions on the NCWS form.
Second. Okay, any more discussion?
Would it be beneficial to have him come in for an interview before we give him a license, or would you rather just not?
I think let's go through the complaint process and see what, and then the complaint process may be before we do that, we want him to come in and talk to us or something. I don't know.
And ask him to take the laws and rules exam.
Okay, any other discussion? Okay, all in favor of the motion? Aye. Opposed? Okay. Okay, Steve, the next one, Taraski.
86, if you want to look. Well, let me say one other thing, since that one's over. Typically, what I see with transportation professionals who work on a team with transportation planners, they will run models like Synchro that we're used to seeing, but they don't use good data. They use planner level data. You know what I'm talking about, Robert?
Yeah.
So you get that pretty picture of the little cars progressing down the corridor, but garbage in, garbage out, So that's the frustrating thing.
They'll use some of that MPO data that's based on some average that they make up, counting the number of cars coming into Tennessee or something, yeah.
Okay, so ASCII applicant does not have 4 years of experience. Well, didn't find that he had 4 years experience either, and I was just wondering what there is to talk about. He does have some experience before his degree. Was that what you all were thinking that we might count?
I said he needed at least 2 more years of experience. Okay. I mean, it looked like he had some.
Yeah.
But I think it was at least 2 years deficient. And I denied him.
He has. Out of school, he started working for TDEC, I think. I didn't know if it was an issue of that experience. But it's from his date of his graduation on, it looked like engineering experience. So I didn't know if there was an issue with that or if it was just whether or not to count previous to graduation.
With me, it was not any problem with the experience he had post-graduation. So he started working for TDEC post-graduation in June of 2015. So I said that tells me he's got 2.5 years of experience right now. So he needs another 1.5 years of experience.
He needs 4 years experience beyond graduation.
I've got a question related to that. Is he working under the supervision of a professional engineer at TDEC? It says Karina Bynum, and I know Karina. She is a PE, so if that's his
technical supervisor,
and I guess I don't know Jimmy Smith.
I know Jimmy.
No, I know Jimmy.
Okay.
I would say yes.
I think he just needs the extra experience.
He's working for somebody now that he should be able to get it from.
Yeah. CEC.
Knoxville, yeah.
Okay. Well,
I would make a motion that he needs an additional 1.5 years experience to complete his 4 years post-graduation.
Okay, do I have a second? Okay, any more discussion? All in favor say aye.
Aye.
Opposed? Motion passes.
And I know this is off topic, but I will give him a little bit of a kudo. On page 293, I really like the way that he did that little chart.
Yeah.
Seriously, I mean, that sometimes is good because you do get confused going back and forth between who is your work supervisor, who is your technical supervisor. And I mean, that may be something we want to consider in the future for how people list that experience. But I appreciated him doing that. That was good. Okay.
And to have as many years with TDEC under PEs is pretty good too.
It is.
Even though some of that was before graduation.
Okay, next applicant, Youssef is one that I can cover. This is international degree, and we have there's a shortage of humanity or general education hours, 10 hours. And so let's see.
It's long, I guess.
Part of it, but I don't think that was the first of it. So that'll get you in the ballpark.
The chart of the humanities kind of worksheet is on 325, and then okay, so the shortage of the general education classes, and using the scorecard we have, it shows that we can get credit for really working practice in the U.S. after 5 years, number of years after 5 years multiplied by 0.5. You can get credit that way, and also for passing the U.S. citizenship test. That so those two things are giving him 7.5 hours, which brings him within 3 hours. And we've got a policy that deficiency of less than 3 semester hours may be waived. And the only reason I didn't is, one, I didn't know if we needed to waive it as a group, rather than can we individually waive it. But the other thing, at one time, that 7.5 was 7. So it was right on 3. And I said, well, it's not less than 3. So anyway, I think the rest of the application is good. The coursework is good. The references are good. There's 15 years of experience there. So I would recommend that we approve the application.
Second.
Okay. Any other discussion?
Just a quick question for staff, because you're absolutely right. I just assumed that the individual reviewing it had the right to waive that less than 3 hours discrepancy. Is that at the individual level, or do we have to agree to that as a committee? Liz? Sorry. Does the individual who's reviewing the application have the authority to waive the 3 hours and less discrepancy, or does that have to come before the committee for approval as a group to waive the 3 hour discrepancy?
This is where we giving credit for general education, and we've said if you're within less than 3 hours of having enough general education hours, we'll waive the requirement to have all 10 hours.
Outside of the normal policy, when you individually review, I would think you would all need to agree to it.
But less than 3 hours is the policy, right?
But less than 3 is a policy that we can waive it, and we're just.
And that's why we've got policy, so we can make the decisions independently if we're backing it up with. I mean, if we don't have policies, we just have to make every decision as a board. So if we got a policy, follow the policy and be done with it. So
That's what I just like.
Okay.
I'd like for that to be stated.
You got the power, Grasshopper.
That's fine.
What's the rule that we're looking at? I guess we could give you. I think you're probably referencing a rule that's out there that talks about substantial equivalency.
It's the general education policy that we kind of have been messing around with. Engineering, it's under engineering committee policies, guidelines for allowing. It's down that area.
Let's see if it's on.
Criteria for fulfillment of ABET, humanities, social sciences.
Yeah, you're reading
Looking
something.
for a
Sorry, that's
citation.
why
He's
I was
looking for a
That's what,
citation.
sorry. Yeah.
Oh, I'm sorry. Okay. Yeah, I was going to hand you that too.
Tony, we wanted some.
And I've invaded Glenn's space here. Sorry.
we wanted some consistency in reviewing foreign degrees, and so that we were treating people some.
And it's the passing test U.S. citizenship three semester hours. That's not what I'm looking at, is it?
That's it. I gave him that sheet you're looking at right there. That right. That's what he's looking at.
No, yeah. If it falls within the scope of these policies, I think you all just need to recognize that's what you've done, and then just have that noted in there, and move along with it.
Okay.
Yeah.
Okay. Well. Okay, and why don't we do that again? Because I didn't actually make the motion. I made a recommendation. I'm going to make the motion that we approve Youssef's application.
Second.
Okay, any more discussion? Okay, all in favor, say aye.
Aye.
Opposed? Okay, application. Okay, Alton. The audit.
Wanda, is he applying to go into retirement, or was he applying to get his PE renewed?
I couldn't get that straight with Sandra either.
Which he had not.
He couldn't find the documentation, he said.
Okay.
And so he decided he'd just go into retired status. Rather than get the documentation, he decided he'd just go into retired status.
The scenario is initially he applied for his license renewal, and he was audited, and he couldn't come up with the appropriate hours. Even in the documentation he provided 20 hours. They're legitimate hours, but they're short 4 hours. And I guess when he was notified, you're short 4 hours, he couldn't come up with the additional documentation, so he indicated, it was in writing, it was in an email that said, for your information, I'm retiring from the practice of engineering, would like to retire my license. So we can't grant him a renewal. Let him retire would be, I guess, my recommendation.
Yeah, I think it's one of those things where it's like, well, you know what? I don't want to take 4 more PDH hours, and I don't want to go fight maybe I signed the wrong thing and I shouldn't have. So rather than trying to go fight it, I'm just going to retire it and be done with it. And I think that's fine with me as long as we note somewhere in the file, and I think we would have a history of that, wouldn't we? Where we said he retired and he was short on 4 PDHs. Filled out the form incorrectly or whatever, just in case. Well, you can unretire one, can't you? Or when you retire,
You can, but you have to go back and meet the PDH requirements.
Yeah, I think we need to just note that in there as a. I mean, that would be my motion on it. Unless you want, why don't you make one? You've not made one in a while, and I enjoy hearing your motions.
I would like to move that in view of the fact that he was 4 PDHs short of meeting the minimum requisite requirement for renewal of his license, and subsequent to that requested that he be allowed to retire his license, that we honor his request and allow him to retire.
Second. I'll just add some discussion. After receiving this by email, had a little back and forth with Sundar, and one issue is that he answered, checked the box that he had the PDH hours on the application form, and that either it wasn't so, or he lost his homework. One or the other, and I think that
Which can be understandable.
it can be, and so, but the question really was, is this complaint worthy? And I felt like a little bit of what Tony said a little while ago, the fact that there's that he agreed to retire, that's like the biggest penalty that you can have, is not having a license. And so I don't see a need to do anything in addition. But if he were to want to unretire in about 6 months, I would like a note in the file that we ought to talk about the little box and get a little more information on that.
You have that record, though. In the event that he wanted to unretire, you would have it recorded that
All
he
his
was
documentation
deficient.
goes in his record.
Yeah, so that'd be part of the record anyway.
Okay. All right. Any other discussion? Okay. So the motion, let him retire. All in favor, say aye. Aye. Opposed? Okay. Motion passes. Okay, we got an email on Lindsay
Page 263, if
263.
anybody's hadn't found it.
Okay, in looking at the email, I know I can't remember whether it's a policy now or a rule. I think it's a rule change that you can't double count master's 1 year at the same time of work experience, post-graduation work experience, that you're either counting one or the other. And so by my simple math, it looks to me like the applicant needs another 1 year and 4 months. Just taking master's was obtained June of 2016, and then there's been a year and 8 months between June 16th and February of 18. So there's been 2 years and 8 months of experience. So the applicant still needs a year and 4 months. So my recommendation is that's the answer, that there's a no on October of 2018, that it's really October of 2019 would be the first available date they could take the test. So that's my recommendation.
Second.
Okay, all right. Any other discussion?
I agree with you, but you got to love these people that are really eager to get their license.
Well, this case, though, and just quickly, this points out one of the things that I think we would have issues with. I still the person that's working full-time and going to get their master's, I still have I still think there's a case to be made, but they readily admit 20 to 30 hours for a lot of that. I mean, so it's hard to, how much time are you working on your master's? How much time were you working really doing full engineering work? So I think that points out one of the hardships of that, or the hard.
I agree with the motion.
Yeah, let that be an exception if somebody can prove. Yeah. Okay. Okay. Any other discussion? All right. All in favor of the motion, say aye.
Aye.
Opposed? Motion passes. I think that is all the applications. All right. Great. Thank you. All right. Let's see what's new business, I guess, is next. Know that I have any new business, but what do we have some new business?
Where's
I've got one
tomorrow's
or two
agenda?
things.
Where is tomorrow's agenda?
It's on the
What page?
iPad. It's under books.
I just looked at that and I didn't. iBooks, right?
Did we want to
Library.
discuss the definitions?
Yeah, that was my question. So my question was, had we decided to have a definition? Did we take a vote on that and I just missed it? I didn't think that we had.
Didn't, are you referring to my documents that I
Yes.
gave you in preparation for tomorrow?
Yeah.
You didn't vote, you kind of, I think the board agreed that you wanted to look into it and look into what some of the options would be for the definitions, and if you could include them in rule, you'd like to investigate that route before including them as a statute addition. So I brought some initial language to the board, and we narrowed it down to the language that you have in the red line that I passed out. And then this is the language that I'm seeking some further suggestions on. And Ricky made, Mr. Bursai made some edits that you should see in red handwriting.
We need to then review this some more based on their edits. Are we going to vote on anything tomorrow? Because
You
there is a part on the agenda that we are doing something with the rules voting. I thought
So
voting.
I gave you three different things that will be under legal's portion tomorrow. The first thing in the packet is a red line that has the changes to the co-op credit for the engineering committee. It also has a change for the architectural committee as far as what the interns are able to refer to themselves as. So that the co-op rule is the second one listed, and if you had any further changes to that, we could discuss them in this committee. We could also discuss them at the board meeting, or if you believe they're ready for a vote to move forward, then we can also vote to move those forward tomorrow at the meeting. And I will give the architect committee a chance to review their portion of the rule as well. If for some reason one rule is ready to go forward and the other one is not, I can sever the two of these and we can send one of them forward if it's ready. Or if both of them are ready, they can both go forward. The second document, you'll see there's two things in here. One, Mr. Campbell, you had submitted some changes to the seal statute that you thought were appropriate, especially with the rule change that we recently proposed. And then the second part is the definition of architecture and engineering practice. The language on the second part was taken from, I believe it was Alabama and Missouri, a combination of the language that the board liked from each of those states. And accepting further edits now, and if the board decides you want to move forward with adding these definitions to the rules, we can look into that as well. The third document I gave you is the application reference sheet. There was requests to expand the questions, provide more room for written response. And I've made the changes that were requested by the board, but also Mr. Bursai added some additional changes in red handwriting, and we can play around with those changes. And if this form is ready to move forward, we can the board can vote to approve it and then it just goes through a legal approval before the board staff would be able to use it. So.
Why don't we take those in order of this packet of what
Yeah.
we're looking at, and one by one here. And the first is the rule change on progressive experience, where we're basically adding the avenue of getting 1 year of credit for some experience prior to graduation for 3 years. There's that language there. Has everybody looked at that?
I was good with the language that
Okay.
was written on, that was the extra
Okay.
year. Yeah, that was fine.
Okay.
If the committee is comfortable with the proposed language, you can vote to recommend that language to the full board at tomorrow's meeting, or you can take the time now to provide me with further edits that you'd like to make.
Has everybody looked at that one enough to feel like we can proceed on that? Okay.
I'd like to say I'm really excited about getting to this becoming a rule. So if we can move this one forward, if everybody feels good about it, and if not, let's take the time to talk about it, because this is a pretty big deal to a lot of our candidates that want to accelerate, like we've seen earlier today in our discussions, people who are trying to accelerate getting registered. This is a big deal.
And Liz, thank you for that qualifier in there, really helps us too.
It does. Thank you,
Where it
Liz.
says applicants are limited to gaining 1 year.
1 year.
1 year on any of
Right.
these options, but
And,
just 1 year.
and no
that's-
partial credit.
Yeah, I think that to me made it
I
very
mean,
clear.
and what that tells me is if you've got 2 years of experience, looking for 3 for 1, and we're not going to give
I'm going to get 8
2/3
months
for
credit.
2 years.
No.
Correct.
Yeah.
Correct.
If I'm
And
reading
we're
that
not
right.
doing the masters, and then you got 3 over here and all that. It's just you get 1.
Right.
You don't get a basket of options.
And I'll take 2 months from
Yeah,
this
yeah, there you go.
category.
Please give me
6
yes.
months from that category.
Okay. All right. Well, do we want to have a motion?
I'll make a motion that we approve the language as written under Rule 0120-01-10 Education Experience Requirements, 2A and 2B, I believe, if that's appropriate, and send that to the full board for approval.
Seconds. Any more discussion on that one? Okay. All in favor of the motion, say aye.
Might need a
Sorry.
roll call.
We used this rule before it was a rule with someone that worked for Harold Cannon.
Correct.
We didn't?
I mean,
I don't think, no, we didn't use the rule. We just told him we were going to get a rule.
Yeah, legal.
But didn't
told
we
you that
approve him
couldn't-
to? We didn't? Okay.
Told him he could go to Kentucky and get licensed, and we told him something else, but we didn't allow him any extra flexibility, I don't believe.
But this rule would definitely be a positive move for the board because it does allow more people to gain that progressive experience requirement in an alternate way. So
We told him, I believe, Stephen, this may be where it is, we told him that hopefully we would have this rule in place that he could take advantage of it. By the time it's in place, he would be, and it would cut some period of time off of his experience, I think is what we told him.
All I was going to say is, that the Tarasky that I reviewed, he had multiple years of experience with TDEC under Paul Schmierbach.
I don't know that was engineering
Well,
experience. So
yeah,
because
we'd have
he-
to talk about that. I just wanted to make sure we didn't need
Yeah.
to bring that one back up.
because that was pre-engineering
not
degree
approved this year.
for him,
Yes.
and that was more environmental, more
Permitting
biology.
and review.
It wasn't necessarily engineering experience.
It wasn't design work like.
Correct. This person has worked for an engineering that prompted this
Yeah,
really
yeah,
work.
Yeah.
Yeah.
Let's remember, this won't be in effect for several months, right? Several
process is-
months.
yeah, a rulemaking process can take up to 9 months before it becomes effective.
Okay.
Good, I interrupted the vote,
No, no,
but
no.
go ahead.
No, any other discussion?
Nope.
I'm-
Thank you.
Okay, all right. All in favor of the motion, say aye.
Aye.
Opposed? Okay, that we say is approved. Okay, next, I believe we have the law on the seal, a markup there that I know I had some comments on, and that's what Liz contributed. And is that one that, Robert, did you prompt it? Do you want to kind of tell us why we're doing this?
Well, this is a different one than I thought I had looked at.
Okay.
Now, maybe I may be.
Okay.
Let me go back through my notes here. Maybe. The one I saw had like ABC, right? It had digital. It had.
That's not this
Okay, it was right here. It was on. It was this one. Started here.
Is that it?
Oh, we're not talking about the seals rule. I'm sorry. We're talking about, you had some suggestions for the statute that refers to seals.
Okay.
Your
'Cause this
seals
is-
rule has already
That's
been
what I
approved,
thought.
and it's
That's-
already
okay.
going through the review process.
That's what I
by
thought. I
legal.
got.
Yeah.
That's why I got confused.
Yeah,
I was
no,
saying,
I'm
well, why are we
sorry
talking
about
about
that.
this one again? Because I thought, it's in here. So.
No, this would be in the statute. Do you guys have a copy of this statute?
Dude, I'm sorry. I got confused on which one we were talking
Well,
about.
I apologize about that as well.
Because I listened to your motion and I wasn't able to comprehend all that.
Flabbergasted from that.
Yeah. I'm sorry. Go ahead.
Liz, do you know what the thrust was of why this was rewritten? I'm trying to remember.
I don't. This was brought up a couple meetings ago, and has been, I think, in the works since then. I don't think we resolution, so it's just still kind of on the table for discussion. Wants to give a background to what the change would help with. I thought that it was in connection with our rules that we've been sending through seals.
Looks like what has been done is we've taken out specific reference to registered architect, registered engineer, registered landscape architect, and just said licensees, kind of not named
Yeah,
each
I
of the
know.
professions.
I got why this was on your thing. So we have on here in the marked out part, it says the registrant shall stamp with the registrant seal all original seats of any bound sets of plan in the first sheet of any specification or reports prepared by the registrant. So we're talking about the first sheet. Now, let me make sure I'm getting this right. And if we do what we're talking about doing, as that goes through, it's that first sheet could potentially be different. And I think I was just trying to find, and it may not be, you tell me if it's appropriate or not, we can throw this away if we need to, but I thought we would have to change this subsection B to make it allow that as well. And again, I may be wrong, but it says, and I wanted to leave the architects and all that out because they may not want this same provision to stamp a index sheet in there, and I just said that should be left out. One seal in the form approved by rule of the board. All final drawings, specific plans, reports prepared by the licensee being filed. I was trying to narrow it, get rid of the first sheet thing, and make it more generic, I think, and I may have failed miserably in that. But that was the
Was
I
it all?
understand. Now that you're explaining it that way, I don't think it's necessary for our rule.
Okay. Well, if it's not
to move
necessary, just
through.
leave it alone then. I mean, there's no sense in, I thought I had to change it because it listed the first sheet of the document down here, and if it doesn't, throw it in the trash can.
Legal can review that after the meeting. Certainly, the AG's office won't let the rule move through if it conflicts with the statute. But I'll double check everything and make sure that the new rule would correspond with the current language. But I don't think we need this statute change.
Don't need to change.
Yeah, because I think the seals law referenced back to 62-2306, and that's probably why I thought we had to change some of it too. Okay.
Robert, let me ask just to make sure. This is, I think this may be a little different question. You were focused on wanting to change that where it says first sheet of any specifications. Wondering if this language in the crossed out version says the registrant shall stamp with the registrant all original sheets of any bound set of plans. And you were
That's right. That's it.
You
I
were
was trying to
saying-
get rid of that language.
you were trying to get rid of that language because of this massive set.
That would have the index sheet, not all original
Correct.
sheets stamped.
So were you trying to get this passage ready to accept that method?
Well, we've already got that method.
Is in the rule?
Is somewhere.
Internal approval process right now.
But I didn't know if that would be in conflict because it does say all original sheets instead of the index sheet. So that was my purpose, was going,
So is it going to say two different things? I mean, we're going to have a rule that doesn't say the exact thing that the statute does? Or
Well,
they're saying different things, I should say.
We'll make sure internally that they don't conflict. I will, since it's still office, I can address this with my supervisors. Not been brought to my attention yet from the people above me that have reviewed it that there is a conflict, but I will bring up this statute and the suggested change just in case. Valid, obviously, so.
Okay, so
I don't
you'll,
think the
you're
committee
going to
needs to
look
take
at
action. Legal will take action on
Okay.
making sure that it corresponds.
you're
And
going
if
to
it-
you're going to look at what's crossed out in red and say, does that conflict with the rule, the proposed rule change?
Right.
Okay.
We don't really need to take any action on this until she's had a chance.
I was just worried because the two didn't, to me, it didn't line up because it had all original sheets in there. And now we can treat the index sheet as the original sheet, I suppose. And by the way, just whatever, I think TDOT's hopefully going to this by July 1st is what their goal is. So, I mean, I think we're in decent shape to get there based on what we've talked about some with the expedited process.
I will just say that we should have a concern for the rest of the industry, like the world I live in, the building industry, that we do not allow just a stamp on the index sheet, because sets are taken apart, split up, and every sheet needs its stamp. I think everybody in the building world sees the value, would see. Whatever the wording is, it needs to not allow that for the other type of sets out there in the world.
But I think, and again, I think that as we move into a more electronic data transferring world, that issue is going to be a zero type
Maybe
thing.
we can base it on language that says,
But we
it's
have
gotta-
to have something in the middle.
It's
You're
got to
right.
have this software that can verify every sheet, if something changes, and that might take. All right, so we're going to move on and we don't need to do anything with that seal stack. What Liz put together on the practice of architecture and practice of engineering.
Conversation might be better for the full board, so you can have the architect's input, because I know that practice kind of touches both of your professions. Offer any edits. I'm fine to accept those now.
Comment I had was that it seems definition of the practice of architecture allows incidental practice of engineering, and it defines that. And thinking it would be likewise, the practice of engineering would allow incidental architecture. And I think it's that way in other states that have. So you would really need a definition of both incidental practice of architecture and incidental practice of engineering. But I have the same question Robert has. Is this something tomorrow that we're just going to discuss as a board, or is this?
Yes, this is
ready
on the
to be
agenda.
enacted?
This is on the agenda tomorrow for full board discussion.
Okay.
But not voting on it, anything?
I don't think it's ready to be voted on
Okay. Just-
at this stage, but flush it out more, make some additions or eliminations of language that likes or dislikes, and then probably for the April meeting, the board could vote to add it to the rules.
Say that a lot of this verbiage came from Indiana?
The board liked the language that I think it was Missouri and Alabama used. So I took a combination of the two based on feedback of likes and dislikes of certain portions of those states' definitions, and also looked at what corresponded with what our statute and rules already mentioned or didn't mention. I believe legal thinks that it's possible to add this as a rule change, and if not, or possibly adding it to, or proposing to add it to the department's legislative list for the next session, not this current one.
Do we want to discuss this at all?
I said I'm not in favor of the practice of engineering, but I may be outvoted. That's just my discussion.
And Mr. Campbell, if you have specific edits that you'd like to send me, since this isn't, this isn't ready for a vote, you can email me before the next meeting or give them to me.
On the practice of engineering one, yeah, my edit is I don't think we ought to have a definition.
Maybe that's what our discussion needs to be instead of getting into the details, because
Yeah, I mean, I think
we know
that's right.
we know that the architects want to do this. They seem to be they're all in agreement, and I don't know, is it proposed for landscape architects too, Liz?
No, just architects and engineers right now. I think landscape architects didn't seem to want to join in on the last couple meetings.
I think my opinion has been, I don't mind having a definition, but I certainly think that if the architects are going to push through and the board votes to have a definition of architecture, I think we have to have a definition of engineering. So that's sort of where I land on it. If we get pushed into it, we definitely got to do it whether we want to or not, because I think it would be even more confusing if one's defined and not the other one.
Just my comment, you could always say, we know what we're not.
And
Just the
it's-
definition of architect, that's what we would not be.
I mean, we can do that.
But yeah.
I just don't. I mean, I'm not sure why the architects want to jump in this. It's almost like it just got recommended by NCARB or something, and it's just like, okay, we want to do that. And I understand, and you and I've had this discussion about, some issues that come up from time to time with drainage or surveyors or whatever. But the arguments that we have, those arguments are not, there's just not a lot a ton of them. Every once in a while we have one, but it's not something that's prevailing in our industry. And I think we take away some flexibility from the person that has been classically trained in some of the orders or whatever. What am I trying to say? But anyway, to be able to do both things, and it opens up just another thing to argue about. And we've gotten along pretty well as a board, and not having that argument for a long time. And we hash it out among ourselves rather than somebody saying it says right here that and you're like, okay, well, it does say right. I mean,
Well, I think the reason why legal did pull some research as far as the proposed definitions was because the full board did decide that they wanted to try to be more uniform with the other states. We are one of the only states that doesn't have a definition. But if the board decides they want to change the direction on that, we do not have to add these at all. Just a proposed
I
item.
ask, how do we determine what practices of engineering services are incidental to the practice of architecture?
I think I would leave that up to the experts to help me craft.
There's a
The
little
rule.
bit of a definition in there, and it's never going to be
Comprehensive.
It's never going to be dotting all the I's and crossing the T's. But there is
either there's a line of demarcation or there's not. We don't work in Venn diagrams.
well, to me it reminds me of it reminds me of what requires a seal and what doesn't. A lot of that there's some of that is subjective when it gets into renovation. And this is similar to that, and they talk about you can't design the system. You can do some changes to the system if you're not adding like the big stuff.
Again, let's how do you regulate or define that? Because let's say an architect moves a wall. Then they determine, look, we're just going to go ahead and shift this electrical over, and we're going to shift this mechanical over to go along with it. Well, they have potentially made changes to a mechanical or electrical system that could impact its operation or its functionality, or change the design intent. So, I mean,
I don't think defining it helps us with issues we have between engineering and architecture, because we deal with those. Probably half the complaints that I've reviewed since I've been on the board is either an engineer doing a whole set of plans for a church or an architect doing a whole set of plans for a church. And we look at it, and if they're qualified to do it, we don't say much about it. And if it's an architect doing a little bit of electrical and it looks okay, then we don't say much about it. It's when we get electrical drawings and there's just a bunch of lines that don't even talk about the size of the conductor or any of the details that you might normally see. That's when we raise the red flag. But one way it would help us is with professions that we don't regulate. That there's some overlap, particularly in civil engineering, like with there's a definition in the state law for geology now, and obviously surveying's had the NCEES definition of land surveying in their law for a long time.
We've traditionally held pretty hard lines on that. Remember, you may not have been here, but Rob's old analogy: surveyors measure, engineers design. And I always like that. It's pretty easy, makes it fairly clear. But there's also something to be said about this continued effort to sort of erode what we do and allow other entities without what's Phillips' three-legged stool components to eat into the profession. And one of the reasons I didn't like this is because I think that's what it does a little bit. It gives them the authority to practice engineering just because they are somewhat familiar with it.
I mean, architects, yeah.
They have that. They can do that now. I mean, like Steve said, it doesn't change now that if they do some of that and they stamp it and they know what they're doing, if they come before us, we will allow it.
This basically says they can do it. The way the law is written, we get to adjudge whether or not that's true or not.
But we'll still judge that later because, I mean, you can't if you don't do a good job of doing architecture, we can rule against an. They don't know what they're doing. They've got to know what they're doing, whatever they're doing, architecture or engineering.
Then why not just let an engineer do it? I mean, if it's something that's a normal engineering function, why not just hire an engineer to do it?
I think that's right, but that's the same question. Whether we have the practices defined or not doesn't change what's going to come before the board, is what Steve's saying, and how we're going to look at it. And I kind of agree with that. It's still going to come down to that.
You know, I don't want to introduce language that basically says they can perform engineering services. Again, I agree. Maybe
but we do let them do that.
Well, to an extent, but we
Yeah.
review that pretty heartily. And again, I agree that a big part of the complaints that historically we've gotten are people that bleed over into something further than they should. Well, what we're doing is we're blurring the lines, I think, a little further with this language.
I thought it was interesting. Look how much verbiage we use to talk about surveying.
Yeah.
You know, that just tells you historically what a problem it's been trying to decide what's surveying and what's engineering, because we go to that extent to try to say what's engineering surveys versus land surveying.
I would like to point out that if the architects would like to have the practice of architecture defined in the words that we have in front of us, the practice of architecture is defined in seven lines, and the engineers is defined in 3 very long paragraphs. So I'm not just, if they're the ones who are promoting the definition of something, then that seems like it's a pretty broadly interpreted definition compared to what we say. Or not what we say, but what's been presented on a piece of paper.
And I think that's the standard language that's been out there.
Maybe this is the conversation that has to happen at the board meeting tomorrow. Is, I said it before, but the system we have has been working. So what are the reasons for wanting a practice of architecture?
Well, specifically to include incidental engineering, incidental practice of engineering.
Well, the thing is, the big thing
We're going
is
to have engineers that are going to want us to say that they can have incidental practice of architecture. We know one in Knoxville. A lot of his work is really what most people would say is architecture, but he's done it for years and he can do it.
Yeah, and there are structural engineers that build maybe a concrete block, simple storage building, or
an architect will take the definition of architecture and say, well, an engineer can't do anything to a building unless it's under the direct supervision of an architect, because you could interpret it that way.
So that's why you say if there's a definition.
We're going to have definitions. There's going to have to be some degree of incidental practice. We'll be cutting somebody out of their livelihood.
I agree.
I don't, and let me tell you why. On any major project, or maybe even that many minor project, most architects have sub-consultant arrangements with engineers, structural, electrical, mechanical, civil site, whatever. And on almost any project that they do, there are engineering components to that project that they sub to an engineer. Okay, just by virtue of the fact that they've done something for a very long time and they've seen a set of plans over and over and over again, doesn't necessarily make them qualified to design those components of the system. And again, I think this definitively blurs the lines much further than it is right now. And I think that the way that we've behaved, the way that we've interacted with architects historically is the architects design the building component, the building itself. The engineers provide all of the support services, structural, electrical, mechanical, civil side. This has the potential for modifying that a little bit and giving them a lot more latitude and expanding the role of the architect in those building components, design of those building components. And I don't think it should be that way. I mean, you have a firm that's a mechanical and electrical firm. A lot of your work is driven by architects. Those are some of your clients, and it should be that way. Structural engineers are the same way, but they know and understand what they're supposed to know and understand what their limitations are. I think that by integrating this into a written, whatever it is, law, statute, that we're more blurring the lines and giving them more latitude to perform engineering-related services beyond what they should be providing. I don't think I agree with Steve that I think if the roles were reversed and we were saying we can perform architectural services incidental to engineering, I'm not sure if I were an architect, I wouldn't support that.
And I think we need to have that whole discussion. But I think, and the point that I agree with the most is, in order to protect the health, safety, and welfare of the public, we need to define the boundaries of what this board looks at. And I think we need to combine it in an architectural and engineering framework, because you're 100% right. The biggest threat to health, safety, and welfare of the public is not necessarily an architect that will come over every once in a while and do a little bit of a footing, or an engineer that'll add a door with a typical detail to a building or something that's a structural engineer or something. That's not the biggest threat to the health, safety, and welfare. The biggest threat to the health, safety, and welfare is when a geologist decides that they can do a foundation design. The biggest threat to that is when a planning organization decides that they don't need traffic engineers, they need a synchro model using some data that they pulled off the internet. Those are the biggest threats. So from that standpoint, I 100% agree with you. Now, how can we get that to where the boundaries are well enough defined or limited to where we protect the health, safety, and welfare to the point of these people that come in, just like the issue we had before, oh, I'm a traffic engineer. Well, you may or may not be, but if there's nothing there to provide limits, I hate doing it intra-board with this definition where we've got an architect and engineer, because I think you got the people on this board that can decide you're competent or you're not. I think that's what this board's made up to do, and it protects the health, safety, and welfare, and has for a long, long time. It's the people outside the sphere of this board, the registrant body, that is the biggest threat. I mean, when you've got a contractor that comes in and says, and we've had that instance that we've had a complaint on, where it's like, oh, a contractor went and picked the HVAC units out, and he picked there's a program online that let him size the ductwork or something, which I'm confident there is, and he went down to Lowe's and got some sheet metal and made his own. I mean, that's the threat to the health, safety, and welfare. It's not us between ourselves. It's the stuff that's coming from the outside. So, I think if we could come up with a definition that embraced that, that's good. But I'm just afraid we're going to spend a lot of time nibbling on the edges amongst each other, and the real threats out there, geologists designing a foundation. I mean, that's what I'm worried about.
I think maybe 5 years ago, we were here, and the surveyor's licensing board came and approached us about they wanted to propose legislation that gave them the authorization to do site plans and do drainage calculations. And this board, mainly led by the engineer, said, no, again, surveyors measure, engineers design. And I think, I agree with you, probably NCARB developed this language specifically to give architects a little more latitude in what they did. Maybe this could grow to be very broad latitude. I see it as a potential erosion of the differentiation between what an architect is trained by education and experience to do and what an engineer is trained by education and experience to do. And I don't think we should begin that erosion.
Well, let me talk about the surveying thing for just a minute. The surveying board would not go along with this definition because we're saying in this that engineering surveys can locate right-of-ways. Well, that's land surveying. You know, there's no, that's not even a question. You know, the engineering surveys that I think most civil engineers want to call engineering survey has nothing to do with property lines. So if you start talking about with the surveyor's board anything to do with property lines, it's going to be a battle that I don't think we need to fight, and I think we'd be wrong to
all
fight
the
it.
engineers would have an issue with their errors and omissions liability insurance providers too if they started doing that, because that's one of the single biggest. I
ain't seen that language before. That's probably that. I don't think that's in the NCWS definition. That must come from Alabama. Sounds like some DOT wanted to maintain control of that because it talks about right-of-way easements and acquisitions. That's DOT sounding stuff to me.
They didn't want to have an RLS on staff.
That's right.
That's what it amounts to.
Yeah.
That's what it amounts to.
I wouldn't want the service board to think we're proposing that.
So we've got a lot to talk about before this would ever come to be, these days.
Well, but
Go ahead.
Ricky, it seems to me like since this is the engineering committee and
Yes.
this is a piece of paper, that we should at least have some level of statement relative to this piece of paper so that we don't go into tomorrow's meeting with any misunderstanding with the architects that they somehow would think that we're even going to discuss it. Because it sounds like we're not even ready to get to a point where we can't even decide if we want to define, much less what the definition is. So I don't want to go into tomorrow with they've got a definition and we've got a definition, because that's starting the debate at the wrong point for my purposes.
Kathy, it sounds like you're saying that the committee should be unified, that you are not comfortable with even having a definition, and to present that to the architects and say, hey, even though one is listed on this sheet, we're not even sure if we want one, and
Right.
let alone we don't like this language.
Right. Given that they're meeting tomorrow morning before we have our board meeting, I don't want them to meet at 8
Well,
and under the assumption of something that we've already
Right.
decided is not true.
So actually, this wasn't really on the agenda to discuss today, and is not supposed to be on the agenda for the architects to discuss separately tomorrow either. It was supposed to be reserved tomorrow for you to all have the discussion together, but since you started into it, I didn't want to stop you because it was really good, very good comments from everyone. But if you want me to give them that heads up tomorrow before the meeting starts to maybe avoid some confusion, I'm happy to do that. Or if Mr. Bursai wants to present the committee's unified view on the topic at the beginning of when the topic comes up at the board meeting, just to let the architects know this is how the engineer committee feels before the conversation is even started, we could do that as well.
In fairness to the architects, I mean, we were given this part of our agenda today. My assumption would be that if they're given this same document, they'll sort of discuss it and make it part of their agenda. We've sort of expressed our opinion. I think it's only fair to them that they know and understand what that opinion is.
But I think they've already expressed their opinion. They would like to move forward with some of this.
As long as
Is
they
that
know-
right? I mean, from a past board
Yeah.
meeting or two.
As long as they know where we stand on it, I'm okay with that. But
That's my concern. I just don't want them to come to the full board meeting with just not knowing where we are right now.
agree.
So a couple things on that too is, I mean, obviously, I think we need to add this as an item for our next meeting for new business or old business, however that works out. Is it proper to not have a full board meeting and to discuss just this thing between the architect and the engineer committee at sometime, next meeting, or
Have a joint committee meeting, or we could do it under like the rules committee, and anyone who's passionate about the change can come sit in and give comments.
just think about, I don't want to sit there with the whole board and discuss, because you got 3 other members that may not really care, and I think it's probably something maybe we just need to hash out amongst ourselves a little bit as we go. I mean, we can talk about it tomorrow
Totally
too.
fine.
but-
If you want to present that to the architects and the full board and suggest moving the item to a later meeting, we can certainly amend the agenda. We don't have a discussion on it. Tomorrow, I don't think there is a rush in discussing it.
I actually like that idea of moving off of the agenda and making a recommendation that we have a joint committee meeting between Architects Committee and Engineers Committee.
Will this be in any public record? The definition of engineering?
This is not this is like a working document for the board currently.
You said a legal term, you said public record. So this is attorney work product that we're presenting you right now until we release it. That's nothing that's been wavered, though. I mean, we're saying this all on the record, though we've been discussing it and we've been talking about it, so you probably have some waiver issues and as to whether or not you've already waived any privilege you would have had because we're discussing. So if the issue comes up, I'd like to look into it more, but
But the title of the document does say proposed changes, so there shouldn't be any confusion. If someone does request the document and it is eligible to be reproduced to a public member requesting the document, it does state that it's proposed language and it's not something that's affecting people now.
Okay, I think that's good.
I just don't want to strike up a battle with the surveyor's board that I don't even want to fight, and this would.
I think we could take Tim, though. Pretty confident.
We just scheduled a meeting, they wouldn't show up.
That's good.
Okay, so this item is going to be taken off the agenda of the board meeting tomorrow?
The board would need to vote to take it off. I can certainly, in the morning, let the architects know the general consensus if you would like, just so they have a heads up. Or if you want to wait and present that on behalf of the engineering committee and the board can vote to take it at that time, we can do that too.
I think what I heard is it'd be good for them to know before they get into their architects committee meeting tomorrow, that's what was presented,
Okay.
what this committee feels is we're not ready, and we suggest a joint committee meeting would be the right next step, rather than bring it to the board, and that might keep them from talking for an hour about it.
I'd be happy to present that at their committee meeting, and then at the start of the board meeting tomorrow, we can vote to remove it from the agenda and add it to a later committee meeting for you all to discuss.
Do we need to make that a motion or anything, or is that a discussion enough?
No, not right now. I think that'll be
Okay.
fine. We'll need a motion to remove it tomorrow.
But not for this meeting. Okay, the next item in the packet is our reference form, and we received a reference form, and I know I made some marks on that in red, and I don't know if we want to continue to look at that and have everybody comment on it, or whether everybody's looked at it, disagreed with the red marks, that's fine, or agree with them, or where's everybody on the reference form?
Oh, it's so much better.
Good.
It really is. I mean, I commend everybody's input on this because it just makes it so much more obvious that the reference needs to provide supporting documentation or opinion relative to some of these answers, as opposed to yes, no, or my favorite, not applicable answer. So I'm pleased. I'm pleased.
One thing I've noticed on some of the other states' forms that I like is under item number 5, instead of having those lines there, you got boxes under each one. You can check a box.
Yeah, we had boxes in the old one, I think.
I think that we can easily make that change.
I think we can do that. I saw that too, Alton. I agree. Because invariably somebody will check between the two.
Yes, they
will. Well,
will.
it was slightly above average.
Maybe that's.
I want their, honest opinion.
It's 1/3 of the way above
Don't let them
average.
do in between. So we have those now, and so we'll keep the boxes in, I believe.
I like it. I like your comments too, Ricky.
All right, well, do we want to make a motion to go ahead and change the form as marked and proceed with it?
I think let's,
But,
do you wanna-
motion to recommend to the full board that you approve the reference sheet as amended, and then tomorrow at the full board meeting, the full board will vote to approve it, and then it'll go through the legal review process before it gets put into regular use.
How will they see these edit marks?
I printed them the same copy
did.
that I gave you guys, so they'll be able to see the edits. So if you're voting to approve or recommend the form as edited with the red line and with the addition of the boxes.
Okay, good. Okay, so we can should we make a motion to say what our engineering committee recommendation is? Okay, somebody want to make a motion?
So moved.
All right, second.
Second.
Okay, all in favor, say aye. Aye. Opposed? Okay. Great.
I think we got one more little
Yep.
small thing, but I don't know. I just see it on the director's report tomorrow about the Southern Zone meeting. Do we need to decide who's going, who's not going, or are we any of us going? I reckon
I think that's already decided.
Those are all updates for tomorrow. Typically, what we had scheduled for today for discussion was just what was sent to you. But as far as the updates, in addition to that, was Roxanne was going to cover that in the general meeting. So we don't have anything prepared, at least not for this committee to discuss.
Okay, well, the only reason I just got on my email this morning, I think maybe that the tomorrow's the deadline for registration.
Well, for NCAAS funding.
Yes.
Yes.
I got a notification from Roxana, though, that I think you, Kathy, and I were supposed to go.
I mean, that's fine. I just didn't know. I didn't have. I just got this
Roxana
notice.
can contact NCAAS after the meeting, but still tomorrow, and get whoever is voted to be registered. A lot of times, the national organizations will let us register, and then we can send the fees later on. So even though I know the deadline is tomorrow, but perhaps we could move that up in the agenda just so there's enough time for the staff to make sure you're registered.
I asked Roxana when this came, and because I saw the deadline, and she said that Kathy and Alton and I were the three decided at the last meeting.
Okay.
And so she said, go ahead and register with NCEES. So I did, but I'm sure that can be undone if we want to change that. I mean, if that's
I think if you recall, and of course, I'm new to your organization, but if there was some time ago when you did the outreach, or the traveling schedule, that the board voted on that schedule, and that's probably where those three were selected, and that's why they were slotted. I think it's really just an update and to formalize and memorialize that process. So yes. And then, yes, you've registered, and so you're good to go on that. But then we just need the board as a formality. Since we've already approved the schedule, the board already reviewed that, said, yes, these folks are going to these events. So they've already approved. But then, I guess as a matter of individually itemized, I can't speak for Roxanne in that regard, but I imagine that's probably where we're going. It's probably more of an update. I don't even know if it's actionable or not, but
I don't remember being told that I was going, to be honest with you.
That's we may have had three or something,
It didn't happen.
but I don't think we had. We may have said we're going to send 3 delegates, and that's
I don't
fine.
think that happened
It hadn't
either, to
been
be honest with you.
discussed.
I agree.
Yeah, I don't think I just don't remember that. That's the reason.
Did you get the email that I was mentioning where we were told that it was the?
I did.
You did not.
But I didn't remember it.
If I
I don't remember it.
It even included a link to the website, and I went to the website and registered
Yes.
as soon as I was told to do it.
Oh, no, then I definitely didn't get that, because I sent Roxanne an email and said, is this going to be decided anytime soon? And she said, we'll take it up at the next meeting. But I didn't get a note that said, go ahead and go do that.
Okay.
I haven't done anything. I thought it was going to expire. So.
Well, again, like Ricky,
You-
I'll be
you
glad
ahead
to
of me.
unregister.
I'm sure they can handle that.
We have a good relationship with NCWS, not to speak for them, but we could do whatever we need to do.
So we
in
do
that
have
way.
3.
But there is
We've been
3.
approved for 3
That's
delegates,
correct.
right? Okay.
Yes, sir.
Okay.
Well, I think the NCAAS indicated in the information I looked at that they would pay for 3 delegates. Not obviously not this organization.
That's correct.
Okay.
That's correct. They're
So,
funded.
and we're just going to do the funded delegates.
That's correct. Yes,
There's
sir.
no money in the budget. Okay.
That's right.
Just want to make sure. I don't really want to go. I thought we'd had a little bit more discussion about this in the past. About
I think we hadn't talked about it. I
I
agree
don't-
with you.
I don't think
No,
we've talked
we
about
had
it
not
at all.
talked about it.
which is
No.
Should we discuss it?
if all 3 is all we can go and we've got 3 funded. Then.
I think it might be better to discuss when Roxana is present at the meeting, just so she can coordinate everything.
Other actionable items that we had covered for this committee? If so, I think everything else was for the general meeting tomorrow. If that's unless there's new business, I believe if someone wants to make a move to adjourn, we can do that.
Just before we do, let me just state for the record that anybody that has an interest in going, I would be glad to abdicate my what I thought was my assigned position and let anybody
do
else.
that. I was going to do that. And
I've already done that
no,
too. I've already.
But now nobody wants to go.
No, it needs to be a board decision. So
I'm just
fine.
curious as to how we decided but didn't decide.
It beats me.
There's a travel schedule, and I imagine that Roxana will
Understand.
shed some light on that as
And
well.
I know the travel schedule, but I don't think we slotted. I think we agreed on what our travel was, but we usually have to wait for how many can we send to each thing, and then we decide who goes based on 1, 2, 5, or whatever it is. And I just don't think we've ever had that discussion. So it's different.
Before we adjourn, Casey's sitting here, and she didn't even get noted on the attendees. Or did you have anything you wanted to bring to the committee? You just sitting here? Okay. Anybody else? I can't see back there. Is there anybody else back there? Okay. All right.
Okay. Well, do we have a motion to adjourn?
All in favor, stand.
I'll count that as a motion. I don't think you need a second to adjourn. So, all in favor, let's adjourn.
All
Right.
other motions.
See everybody in the
Thank
morning.
you. Is the thing on?